Good afternoon. Today's topic, as intended, there we go. Today's topic is investigative interviewing. And I thought I'd just tell you a little bit about myself before we got started very quickly. I've been a corporate investigator for 32 years. I'm a former military officer and prosecutor. And it was in the military that I had my first exposure to what we today in the private sector call investigations. And what was remarkable is that I found in the private sector, at least in those days, early 1980s, investigations, interviews, interrogations were simply done. There was no structure. There were no processes. And for those of you that have been in the military, you know everything in the military is done by way of process and procedures. So I began to collect those things that worked best for me in the conduct of my investigation, specializing mostly in workplace misconduct, employee theft, fraud, white-collar crime, substance abuse, harassment, discrimination. And in the early 1990s, threats of workplace violence. I began to collect what I considered to be my best practices, and before I knew it, I really had some pretty powerful processes that were able to sustain the challenges of opposing attorneys, most often plaintiff attorneys, attacking the investigation, our investigators or our processes, but most critically, provide us the ability to scale our operations. So today what I'm going to do is cover for you a little bit about what I call today the investigative interview method. Maybe. That works better. Okay, so here's how we're going to divide our time. Principally, because our topic is investigative interview, we're going to spend most of our time there. I'm going to spend a little bit of time, though, talking about overcoming denials. For those of you that do interviews, you know that often one of the bigger challenges is overcoming the individual who has decided to entrench themselves and continue to deny in spite of the circumstances and very often the evidence against them. We'll also talk about some of the legal aspects, and I'm going to provide you some information concerning a very new development in our profession, that is the world of investigations, having to do with the development of a new ANSI investigation standard, just promulgated by ASIS. And I'll talk a little bit about that before we complete. Just to help us better understand where you are and your knowledge base, I've got a couple of questions. For the purpose of interviewing, or the purpose of interviewing suspected wrongdoers is to what? Why do we want to interview those who we have identified involved in the misconduct, regardless of what it is? Why do we do that? Anybody? All of them. Yeah, that's probably the most appropriate answer. But what's the principal reason? To obtain an admission. In fact, the purpose of our investigations are to move us, the organization, the fact finder, investigator, to the point that they can sit eyeball to eyeball with the individual or individuals they have determined are most responsible for the act in question. Of course, these other things are useful as well. We want to find out who else may be involved. Maybe there's extenuating circumstances. That's useful to find out as well. Next question, which burden of proof must be achieved in order to justify the discipline of an employee working in the private sector? Anybody? C? Yeah, only discipline. Which would it be? Answer C. Good faith investigation, reasonable conclusion. Here's what it looks like. If you can imagine taking an aerial view looking down on a football field, we have two end zones, midfield. The standard of proof in criminal prosecution in the United States and most industrialized countries of the world is beyond a reasonable doubt. In other words, we've got to run the ball from our end zone all the way down the field and put it into the end zone of our opponent. For civil litigation, it's the preponderance of the evidence. Places such as Europe and Canada, for example, it's called the balance of probabilities. For the purpose of our workplace investigations where there is no prosecution intended, the standard of proof is good faith investigation, reasonable conclusion. And using this model, all we need to do is get the ball out of the end zone onto the field, and you got it, we score. The fastest and most economic way to get the ball out of the end zone is to obtain an admission. Not an admission at any cost using coercion, intimidation, or other inappropriate interviewer conduct, but to obtain an admission in a proper, ethical way. That's all we need. Investigation is now over. Yeah, there's other stuff we want to do. We may want to effect a recovery. We may want to find out who else is involved, co-conspirators, and so on and so forth. But for the purposes of discipline, all we need to do is obtain an admission. Investigative notes are considered admissible even when unreadable, admissible only if signed, rarely admissible, and as such, do not need to be retained. What's the answer? A, admissible even when unreadable. I had an attorney in a deposition one day throw my notes in my face and say to me, I can't read these. And I said, well, I'm not really sure that was a question, but I didn't write those notes for your purposes. I wrote them for me. If you can't read it, so sorry. It doesn't matter. They don't have to be signed. Do we need to retain our notes? Go like this, even if you don't mean it. Yes. There's something in the law called spoliation, the intentional or negligent destruction of evidence. You take notes, create a final report, give it to your customer. When I say customer, I'm talking about your internal customer, whether it's HR, whoever is involved, labor relations, whoever is going to be the recipient of your work product, and most likely the same people that are going to affect discipline or corrective action. We complete that report, we give it to them, we shred and throw away our notes, as we learned at the academy, and guess what happens? Litigation ensues, the demand for the production of documents is issued, and we don't have any notes. Spoliation is actionable, both criminally and civilly. You must retain all of your records. Now, we have to be very careful in what we put into our notes. I had an investigator many years ago who played crossword puzzles or tic-tac-toe by himself. Figure that one out, right? All right. And then he engaged in a game of hangman on the back of his notes. The case went to trial, and if you've been in court recently, jumbotrons and projection of screens like these are used, and there in front of the jury were the back of his notes where he had a grocery list, tic-tac-toe, and a whole bunch of other very personal things after he had already testified that he was a professional investigator. Very damning. So we want to be very careful as to what we put into those notes. Do we put things like guilty of sins, sweating profusely, squirmed at every question? No, those are opinions. The notes should contain factual observations and comments relative to the subject and the issue at hand, i.e. how they answered our questions. During an interview, threatening a subject with criminal prosecution is often appropriate, unlawful, should be used, not be used unless approved by management. What's the answer? Very good. The answer is B. Come on, folks, you can wake up a little bit. Yeah, the answer is B. It's unlawful. It's called extortion. You cannot say to a subject, listen, pal, you better come clean or you're going down the tubes, next stop the big house. You cannot say that. How do we respond to the subject who says, well, what happens if I tell the truth? By the way, that's called a tacit admission, right? What happens if I tell the truth? Will I go to jail? How do we answer that? very simply. We say, well, listen, I'm not sure what the answer is. I'm not a decision maker. I'm only an information gatherer. This is a reason we don't want the fact finder to be part of the disciplinary or corrective action phase, i.e. we don't tell our customer what should be done with the individual. We give them the proof that is needed and allow those decision makers to make the decision.